Hi, good morning, everybody. My name is Romy Jurado. I'm an attorney in South Florida. My main area of practice is business law, and we help a lot of businesses with compliance. This is the reason why I'm doing this webinar today. It's actually our first webinar of the year, and I want to share this knowledge with you all because it is extremely important to comply because this rules has very hefty either fine fees, or they also have a potential prison or jail sentence. So all things that business owners need to be aware of and ensure compliance. I'm going to be sharing my screen, and I do ask you guys to ask any questions that you have in the chat, and I can answer it as I go. This is a very new regulation. The implementation rules have just come out. So I have to let you know I'm giving this recording as of January 26th. Things might change as gets implemented and as it progresses. So of course, it's always the best idea to consult with an attorney right before filing, or if you're hiring an attorney to file, because things might have changed by then. Again, my name is Romy Jurado. I'm an attorney. I'm the founding partner of Jurado & Associates. We're a law firm here in South Florida, and we help, of course, in business law, but we also help in other areas of law, such as immigration, litigation, probate, real estate, state planning, trademarks, and more. With that said, I'm going to start sharing my screen, and everybody will receive a follow-up email with the presentation. So don't worry if you don't get to take down all the notes. Everything will be shared. Hopefully, our video will be recorded clearly, and then we can share that with you all. All right, everybody should be able to see my screen now. So let's get started. Again, this webinar today is about understanding the Beneficial Ownership Information Reporting Rule, or BOI for short, which basically many businesses now have to comply with a new beneficial ownership information reporting requirement as part of the federal government effort to combat money laundering, drug trafficking, and other financial fraud. It requires such organizations to file a statement of beneficial ownership with the Financial Crimes Enforcement Network, FinCEN, identifying the persons who ultimately own or control the company. FinCEN issued its final rule implementing the BOI reporting requirement on September 29, 2022, and it went into effect just this year on January 1st, 2024. All right, first. So again, this all came into play back in 2021 is when it became law, but it's starting to be effective now, starting on January 1st, 2024. So what it is basically is you have to file this report in FinCEN Secure Filing System. FinCEN is the financial, it's basically the entity that prevents financial crimes. And what the reason they did this type of regulation is because before or now, you can create company in many states, such as Wyoming, Delaware, and even Florida, and you don't have to say who owns the company and who controls the company. So they want to stop this money laundering. They want to be able to say who owns that company, who controls that company, right? So basically, starting January 1st, 2024 of this year, all reports must be filed. The reporting rule requires certain entities. So it's not all entities, but for our purposes, most of our clients will need to file this. This report has to contain certain information, and we're going to go through all of that. But it boils down to we have to identify who is the beneficial owner, who owns or controls 25% of the company or has substantial control over the company, and also who is the company applicant. And the company applicant is the individual who directly files or primarily is responsible for the filing of the document that creates or registers the company, okay? And in a lot of situations, I'm gonna end up being the company applicant. In the accountants or lawyers that are forming companies are gonna end up being the company applicant. So if you are a possible company applicant filing companies for others, it is super important that you understand this regulation as well. So reports are accepted right now as we speak. Reports will be accepted starting, or they were, as of January 1st, 2024. However, reporting companies created or registered to do business before January 1st, 2024 will have until January 1st, 2025 to comply, to file their initial report. So that means if you were formed before last year, right, before January 1st, 2024, you have all the way to January 1st, 2025 to file your initial report. If the company was created or registered on or after January 1st, 2024, right, but before January 1st, 2025, so meaning companies created this year, then you will have 90 calendar days to file the initial report. So if you're forming your company this year, you don't have all of 2024 to file. You have 90 calendar days to file your initial report. The 90 calendar day period starts to run from the time the company receives actual notice that it has been created and that is effective, or after the Secretary of State or similar office, it's usually going to be the Secretary of State, provides public notice of its creation or registration, right? So that's when the 90 days start to run. So either when you file and the company is effective, or when the Secretary of State says, okay, the company is effective now, you have 90 days to file this report. And for companies that are created starting January 1st, 2025, and going forward, right? So starting January 1st, 2025, going forward, you're only going to have 30 calendar days to file your initial BOI report. Okay, so if you're in existence right now, and this applies for all businesses, even if you're a single member LLC. A lot of clients tell me, Romy, I'm a single member LLC, I'm not making any money. Do I still have to file the BOI report? Yes, unless your company has filed for articles of dissolution. And we will go into that in a minute. So again, if you have a company as of right now, even if it doesn't make any money, and it was in existence before January 1st, 2024, you have all of this year to file your initial report. If you have a company that was in existence or that will become in existence this year, right, then you're gonna have 90 calendar days to file the report. If you start forming companies as of January 1st, 2025, and going forward, we can suppose forever and ever, then you're only gonna have 30 calendar days to file this initial report. And who is responsible to file this report? We're gonna go into that, but essentially it's the people in charge of the company, right? So it's gonna be the officers, the members, the people who hold interest, the people who own stock. And then sometimes they might find the company applicant responsible, but only if the company applicant doesn't give information that you need to file this report. So it's very important to comply, absolutely. So does my company have to comply and report its beneficial owners, right? This is a little diagram that we did and we can go through it. Basically, the reporting rule requires that all reporting companies file BOR reports with FinCEN within the previously specified timeframes, right? So let's go over those timeframes again real quickly so we never forget. If your company is in existence before January 1st, 2024, you have all of 2025 to file your initial report. If you form companies this year, 2024, then you have 90 calendar days, and then starting January 1st, 2025, 30 calendar days to file this initial report. There are two categories of reporting companies, right? There is a domestic reporting company and a foreign reporting company. If you follow the chart, there is a way to determine if you are or you're not a reporting company, all right? If the company was created, let's say that you have a company abroad in Peru, I'm Peruvian, and you created a company over there. But then you told me, Romy, I need to be able to do business in Florida. I need to be able to do business in New York. So then we didn't form your company in New York or Florida, but we filed some type of document for you to be able to be authorized to do business in that state. Then you are already requiring to be a reporting company, okay? So then that foreign company now becomes a reporting company. If that's a company, right, created under any other law, never filed anything within that state, any United States, then you shouldn't be a reporting company, okay? You shouldn't have to be a reporting company. Let's see, I think I have a question. I'm a real estate agent who has created a PA. Do I need to file a BOI? So let's explain what a PA is. A PA is it's designed as a professional association, but in fact, it's a corporation, okay? So it's a corporation that certain individuals, such as doctors, realtors, CPAs, are able to designate and say, we're using it for this particular purpose. But at the end of the day, it's still a corporation. So yes, you still have to file a BOI report. So for all of those realtors out there that are working under LLCs, PLLCs, or PAs, you do have to file a BOI report. And this is why. If your company was created under US laws in any state, and it's either a corporation, which I just told you PA was, or an LLC, right? And was registered by filing a document, usually as articles of organization or articles of incorporation, or in some states, articles of formations with the Secretary of State, then that company is a domestic reporting company, and you're gonna have to file this BOI report. So there are 23 types of companies, okay, that are exempt from reporting. So this is great news because not everybody has to report. I'm gonna have them listed here in this slide, and I'm not gonna go into detail on them unless you tell me you might be one of those, and then we might be able to. So basically, those entities that are not required to file this report are securities reporting issuer, governmental and a governmental authority bank, a credit union, a depository institution holding company, money service business, broker or dealer in securities, securities exchange or clearing agency, other Exchange Act registered entity, investment company or investment advisor, venture capital fund advisor, insurance company, a state licensed insurance producer, Commodity Exchange Act registered entity, accounting firm, public utility, financial market utility, pooled investment vehicles, tax-exempt entities, nonprofits, entities assisting a tax-exempt entity, large operating companies, subsidiaries of certain exempt entities, and inactive entities, right? So if you fall into any of those, then you're not required to file this BOI report. So what happens? What happens if my company does not file the report on time, okay? The willful failure to report a complete or updated ownership information to FinCEN, or the willful provision or attempt to provide false or fraudulent beneficial ownership information may result in a civil or criminal penalties, including civil penalties of up to $500 for each day that the violation continues, or criminal penalties including imprisonment for up to 2 years and or a fine of $10,000. Senior officers of an entity that failed to file a required BOI report may be held accountable for that failure. This is important to keep in mind. So it's not just the company that's going to be responsible. We all know that companies give you some type of liability protection, right? They cannot go after the ultimate owners. But now they're saying that if you don't comply, senior officers of that entity may also be held accountable. So we have all this time frame that I've discussed before to file a BOI initial report. That does not mean that that ends there. Absolutely not. Whenever companies change in their structure with owners, managers, people that are responsible, you have to file an updated report. So it's not just the initial report that needs to be filed, it's an updated report every time there is a change in the structure of the owners or there is a change of the person in control, and we're going to go into that. Anytime there is a change of the beneficial owner of the company, as is defined by FinCEN, you have to update this report, okay? So it's not one time, forever, forget about it. No, it's every time. So why do you think banks and investment companies are, and money and people, companies that are dealing with money and nonprofits? Because they are already regulated other ways. The companies, FinCEN already knows who the owners are, who the beneficial owners are, because they already have to report that already. And that is why. And then you tell me your condo association is not. Your condo association is most likely a nonprofit entity. That's usually how they're formed in the state of Florida. And again, I'm in Florida. So if your condo association is a nonprofit entity, your condo association most likely does not have to file a BOI report. Because why? Because they're already regulated. For your nonprofit to obtain that nonprofit exemption, they have to comply and say who the owners are. They have to follow formalities, who's responsible, and all these things. So I think the reasons, and this is just me speculating, but the reason why all those entities that I mentioned before don't have to follow a BOI report is because FinCEN already has information on who their beneficial owners are, and they already have to keep it updated because they're regulated in many other ways. Whereas us, forming entities here left and right, having an LLC for this building, a PA for this one, then you don't really have to report who the owners are a lot of times, depending on the state that you form. So FinCEN wants to know who the beneficial owners are of everybody, okay? So who is the beneficial owner of my company, right? If your company is a reporting company, and again, we said your company is a reporting company, if it was formed in the United States, or if it's a foreign company authorized to do business in the United States, in any state, and you don't fall under the exemption that I have mentioned before. So if that's the case, then you're a reporting company. If your company is a reporting company, your next step is to identify its beneficial owners, okay? So it's not just who owns the company that are the beneficial owners. We're gonna go into that. A beneficial owner is an individual who directly or indirectly exercises substantial control over a reporting company or owns or controls at least 25% of the ownership interest of a reporting company. And I want to make this point really, I guess, emphasize it. They want to know who the ultimate human being is. You know, before we could set up a company here, then set up another LLC here and another LLC here, and then the owner was hitting all the way down, the ultimate person. With this BOI reporting, they want to know who the ultimate owner is. And that's why it's so important to go through this analysis. All right. So if your company is a reporting company, then your next step is to identify who, right, who its beneficial owners are. A beneficial owner is any individual, again, who directly or indirectly exercises substantial control over a reporting company or owns or controls at least 25% of the ownership interest of a reporting company. A reporting company can have multiple beneficial owners. For example, a reporting company could have one beneficial owner who exercises substantial control over the reporting company and a few other beneficial owners who own or control at least 25% of the ownership interest of the reporting company. A reporting company could also have one beneficial owner who both exercises substantial control and owns or controls at least 25% of the ownership interest of the reporting company. There is no maximum number of beneficial owners who must be reported, right? So a company can actually have many. So what is substantial control? Substantial control for the reporting companies that are required to identify is all individuals who exercise substantial control over the company. And again, there's no limit on who can be reported for exercising substantial control. An individual exercises substantial control over a reporting company if the individual meets any of these four criteria. Okay, so if the individual meets any of these four criteria, they exercise substantial control. 1, the individual is a senior officer. 2, the individual has authority to appoint or remove certain officers or a majority of directors of the reporting company. 3, the individual is an important decision maker. Or 4, the individual has any other form of substantial control over the reporting company. If you meet any of this, then you might be somebody that exercises substantial control. And then here we have a little chart, and I'm trying to make it big so I could see it too, where we tell you who a senior officer is. So for example, a senior officer can be any individual holding the position or exercising the authority of a president, a chief financial officer, a general counsel, a chief executive officer, the chief operating officer, or any other officer, regardless of official title, who performs similar functions as those officers listed above. Okay. Then we also said that it could be an individual who has authority to appoint or remove certain officers. So an individual has the appointment or removal authority. That is any individual that has the ability to appoint or remove any senior officer previously listed or a majority of the board of directors or similar body. And then we also said it could be an important decision maker. Any individual who directs, determines, or has substantial influence over important decisions made by the reporting company, including decisions regarding the reporting company's business, such as nature, scope, and attributes of the business, the selection or termination business ventures or geographic focus, the entry into or termination of the fulfillment or not fulfillment of significant contracts. All those people can be important decision makers. For example, if they have decisions over finances, such as the sale, lease, mortgage, or other transfer of any principal assets, major expenditures or investments, issuance of any equity, incurrence of any significant debt, or approval of the operating budget, right? Compensation schemes and incentive programs for senior officers, those are going to be important decision makers. Or they can be making decisions about structures, such as reorganization, dissolution, or merger, amendments of any substantial governance documents of the reporting company, including the articles of incorporation or similar formation documents, bylaws, and significant policies or procedures. And then we also have a catch-all, situation, and it could be any other form of substantial control over the reporting company control exercises in new and in unique ways can be still examples of substantial control, okay? And it have different indicating of control or different indications included here. So anybody on this little chart that I read can be set to exercise substantial control. Can I use my registered Florida company to buy property in a PA? I think what somebody's asking is if you can buy property using your professional association. I don't recommend it if you're a realtor, because realtors are only allowed to receive commissions for that in that company, and then that's it. It's only for your commissions. It's not to run a business and run real estate. It's just to receive your commissions in the PA. If that's not your case, then we can discuss separately. Somebody else is asking me, good morning, Romy. If my company was registered by an accountant, then that person has to register too? This is a great question. So starting January 1st of this year, people that are forming companies are called the company applicants, whether it be your accountant, your lawyer, okay? That means they have to let you know that they're a company applicant. And when you do your BOI report, you have to include their information. So you do have to have that. It's a requirement. Don't assume that your accountant or your lawyer is filing your BOI report unless they tell you that they're doing it. Otherwise, it's your responsibility to comply, and you will need to get their information. And we're going to go into that as to what information is required for the BOI report in order for you to file and comply with this regulation. Okay, so ownership interest. Reporting companies are required to identify all individuals who own or control at least 25% of the ownership interest of the company. Any of the following may be ownership interest, okay? Equity, stock, voting rights, capital or profit interest, convertible instrument options, or other non-binding privileges to buy or sell any of the foregoing. Any other instrument, contract, or other mechanism used to establish ownership. A reporting company may have multiple types of ownership interest. So don't think it's just who owns my company that needs to be reported. You could own a company in many different ways, and you can have, equity rights in it. You could have loans that give you the ability to convert them into equity, and all of those might need to be reported. So, and we're going to go into that now. Again, reporting companies must identify all individuals who possess at least 25%, okay, of the ownership interest in the reporting company. And what is ownership interest? It's not just ownership, it's the things that I'm going to mention now. For example, you could have equity, stock, or voting rights, and that is any interest classified as stock or anything similar, regardless whether it confirms voting power or voting rights, and even if the interest is transferable, okay? Examples include equity, stock, or similar instrument, pre-organization certificate of subscription, transferable share or voting trust certificate, or certificate of deposit for an equity security interest, or a joint venture or certificate of interest in a business trust. You also need to identify anybody that possesses a capital or profit interest. These are any interest in the assets or profits of the company, organized as an LLC, which is similar to stock in a corporation and sometimes referred to as a unit. So if you have an LLC that has membership interest, right, but it also has profit interest, which is another way to give people right to receive your profit, you need to identify those people too, if they have 25% or more. Convertible instruments could be any instrument convertible into equity, stock, or voting rights, or capital profit interest, whether or not anything needs to be paid or exercised for the conversion. The related items are also ownership interest. For example, any future or any convertible instrument, any warrant or right to purchase, sale, or subscribe to a share or interest, equity, stock, or voting right, or capital profit interest, even if some warrant is just a debt. So if you have the right to acquire interest in a company, you might need to report it, okay? Option or privilege. Any put, call, straddle, or any option or privilege of buying or selling equity, stock, or voting rights, capital or profit interest, or convertible instruments, except if the option or privilege is created and held by others without the knowledge or involvement of the reporting company. If you don't know that you have this, and you may not have to report it, but if you know that you have the right to convert your debt into interest, or you have a profit interest and things like this, then you need to report it. And then there is a catch-all provision, and they had this for the other ones too. Any other instrument, contract, arrangement, understanding, relationship, or mechanism used to establish ownership. So if you have any type of contract that allows you to get 25% of a company's ownership or profit, then you might need to report it, okay? So what step can I take to identify my company's beneficial owners? And this is going to get a little It's going to be a little intense because it's a lot of information, and I know. If a partner owns 25%, there is no need to mention the owner in the report. Yes, there is, because they own 25% of the company. Assuming this is a limited liability company or this is a corporation, they're exercising 25% or more, so you do need to include them. I opened an LLC company in 2023. I never opened a bank account and I don't need to use it. What should I do to close it? You can file articles of dissolution if the company was never active and it was never having any type of financial gain or sale. If it was never active in business, then you might be able to file articles of dissolution, and inactive companies don't need to be reported. Romy, I'm the manager of different LLCs owned by different foreign nationals who are members. Those LLCs are manager managed. So with the beneficial applicant and the ultimate owners, right? We're going to go into that analysis now. And the way that I'm doing this when we have complex structures is I ask everybody for all of their corporate documents. I ask them about loans. I ask them about everything. And then we fully analyze it in order to be able to comply. So there's a couple of things that we need to do. There are different steps you can take in order to identify the company's beneficial owner, right? Step one is to recognize individuals who wield substantial control over the company. Step two is to identify the various types of ownership interests in your company and determine if the individuals holding those interests, right? Who the individuals holding those interests are. Then the step three is to compute the percentage of ownership interests held either directly or indirectly by individuals. This calculation helps identify who possesses either directly or indirectly at least 25% of the ownership interest in the company. So individuals may directly or indirectly exercise substantial control. Individuals can exercise substantial control through contracts, arrangements, understandings, relationships, or otherwise. Examples of direct ways to exercise substantial control over a reporting company are board representation, ownership or control of a majority of voting power or voting rights, the rights associated with financing or interest. Examples of indirect ways to exercise substantial control over a reporting company are controlling one or more intermediary entities that separately or collectively exercise substantial control over a reporting company, and through arrangements or financials or business relationships with other individuals or entities acting as nominees. Note, for trust, a trustee of a trust or similar arrangement may exercise substantial control over a reporting company. So with the previous example or the previous slide in mind, the following questions can help you identify which individuals exercise substantial control over your company. Multiple criteria can apply to one individual. So for example, the questions that you might want to ask is, does your company have a president, a chief financial officer, general counsel, chief executive officer, chief operating officer, or does your company have any other officers that perform similar functions similar to those of a president, chief financial officer, general counsel, chief executive officer, or chief operating officer? If so, they are senior officers. This includes managers. Does your company have a board of directors or similar body? And does your individual have the ability to appoint or remove the majority of the board of directors or similar body? Or does any individual have the ability to appoint or remove a senior officer of your company? If so, these individuals with appointment or removal authority over your company, and they are going to be people that are going to qualify to meet the criteria of substantial control. Then you could ask, does any individual direct, determine, or have substantial influence over important decisions made by your company, including decisions regarding your company's business, finances, or financial structure? If so, they're important decision makers over your company and they exercise substantial control over your company. Are there any other individuals, right? This will be the catch-all one. Are there any other individuals who have substantial control over your company in ways other than those identified above? If so, these individuals are the catch-all provision, and they are going to be individuals that exercise substantial control over your company. Again, it's important to know that the individuals you have identified will be reported as beneficial owners of your company in the BOI report unless they qualify for an exception. And I'm going to go into those exceptions later. Okay, this is step 2. Individuals may directly or indirectly own or control ownership interests. Individuals can own or control ownership interests through contracts, arrangements, understandings, relationships, or otherwise. An example of a direct way to own or control ownership interests in a reporting company is a joint venture with one or more other persons of an undivided interest in an ownership interest. An example of indirect way to own or control ownership interests in a reporting company are owning or controlling one or more intermediary entities or the ownership interest of any intermediary entity that separately or collectively own or control ownership interests of a reporting company, or through another individual acting as a nominee, intermediary, custodian, or agent. So these are ways or indirect ways to own or control ownership interests in a reporting company. So here again are other questions that you can ask. So to analyze what types of ownership interests are relevant to your company. So we're keeping the other examples above. The questions that you can ask are, does your company issue equity or stock, right? Or similar instrument that confer voting power? Or does your company issue any pre-organization certificates or subscription agreements? For example, when you buy a corporation, you may get a subscription agreement that says you subscribe to this number of shares, but you haven't become an owner yet. You just bought them for the future. That needs to be reported. Does your company issue any transferable shares of or voting trust certificates or certificates of deposit for an equity security interest in a joint venture or certificate of interest in a business trust? If so, then your company has ownership interests that are equity, stock, or voting rights. Do individuals hold capacity or profit interest in your company, sometimes referred to as unit? This applies to LLC. If so, your company has an ownership interest in that are capital profit interest, and your company has an ownership interest that needs to be reported. The other questions you can ask: does your company issue any instrument convertible into share, equity, stock, voting rights, or capital profit interest? Or does your company issue any future or any convertible instrument? Or does your company issue any warrant or right to purchase, sale, or to subscribe to a share or interest in equity, stock, or voting rights, or capital profit interest? If so, your company has ownership interests that are convertible instruments, okay? 8, does your company issue any non-binding put, call, straddle, or other option or privilege or buying or selling equity, stock, or voting rights, capital profit interest, or convertible instrument? If so, your company has ownership interests that are options or privileges. And lastly, does your company have any other type of instrument, contract, arrangement, understanding, relationship, or mechanism to establish ownership? If so, the catch-all provision applies to your company. These are more complex situations. If you have any of these situations, please do not file a BOI report on your own. Work with an attorney that knows what they're doing, so if we can fully analyze it, because there is a lot of analysis and evaluation that needs to be done, right? So after you identify the types of ownership with the previous examples that I gave above, then you need to apply that and see who really controls. You have to determine who owns or controls 25% or more of those ownership interests. If your company has issued options, privileges, or convertible instruments, you have to assume that all of those have been exercised or converted into the calculation. If your company issues shares of stock, is a corporation, including an S corporation, or is not a corporation, but is treated as one for federal income tax purposes, calculate each individual's ownership interest as a percentage of the total shares of stock issued. If some shares of stock that your company issues have more voting power or represent more of the value of the company than other shares, for instance, if your company issues both Series A shares with 1 vote and then Series B with 8 votes, then you will need to take all of that into account. The individual's ownership interest will be larger of the 2 percentages. There's a whole analysis, and I don't want to bore you with it, but if that's your situation, we can look at all of your ownership interests, see who owns what directly, indirectly, through voting power or not, and then see who has 25% of more directly or indirectly, and those need to be reported. Okay, let's go into more simple examples, which might be the stuff that applies to you all, but let me start answering some questions here. Okay, Somebody's saying this has been the most informative, descriptive webinar I have watched to date. Thank you for waiting through this. The government has done nothing to help me. Okay, well, let me tell you, all the information that I've got, I've actually got it from the BOI guide, and I just try to put it together as best as I can. And again, this is a very fluid area, even though the law started to be enforced in January 1st of 2024, there might be some changes. So as they change stuff, I'll try to update it and keep you all informed. So how to determine beneficial owners. I'm sorry, how to determine beneficial owners. Let's go into some examples. So let's say the reporting company, right? Let's assume it's a Florida LLC. If you form in the United States, you're a reporting company. Okay, so let's assume it's a Delaware LLC. Let's just do that for kicks. The reporting company is a Delaware limited liability company. Individual A is the sole owner, right? So individual A is the only owner and president or manager of the company and makes important decisions for the company. No one else owns or controls ownership interest in the company or exercises substantial control over the company. Individual A qualifies as a beneficial owner of the reporting company in two distinct ways, giving no additional information, of course. First, as a senior officer, the president or the manager, individual A wields substantial control over the reporting company. Secondly, individual A is a beneficial owner by owning 25% or more of the ownership interest in the reporting company. Given the absence of any other individuals owning or controlling ownership interests or exercising substantial control over the LLC, and assuming no relevant other details, individual A stands as the exclusive beneficial owner of the reporting company. Consequently, individual A information must be reported to FinCEN. But if the individual A hired an accountant or a lawyer or any company to form their company, they will become company applicants and will need to be reported starting January 1st, 2024. And I'm going to go into that example later. But yes, they need to be reported too. Example 2, how to determine beneficial owners. Let's say the reporting company is a Florida corporation. The company's total outstanding ownership interests are shares of stock. 3 people, individual A, individual B, and individual C. They own 50%, 40%, and 10% respectively of the stock. And no other person, okay? Individual D acts as the president for the company, but does not own any stock. So again, we have 4 individuals, individual A with 50%, individual B with 40%, and individual C with 10%. And then we have the president that basically owns no stock, but he's the president, individual D. Again, individuals A, B, and D qualify as beneficial owners, and their information must be reported. However, individual C does not meet the criteria for the beneficial owner. Individual A, being the owner of 50% of the company's stock, is considered a beneficial owner since this surpasses the threshold of 25% or more of the company's ownership interest. Similarly, individual B, owning 40% of the company's stock, qualifies as a beneficial owner because this percentage exceeds 25%, which is our threshold. On the contrary, individual C, not being a senior officer or exercising substantial control over the company, is not deemed a beneficial owner despite holding 10% of the company's stock, which falls below our threshold of 25% or greater. Individual D, in the role of the company's president, exercises substantial control over the entity, making them a beneficial owner. The status is independent of whether individual D owns or controls 25% of the company's ownership interest. So in that example, all those 3 individuals need to report it, not the one that is not the president and doesn't own any stock, doesn't own the threshold of 25%. Let's go with our third example. The reporting company is a Florida LLC with 2 managers, right? Individual A and individual C. Individual A also owns 50% of the membership units in the LLC, while individual C does not own. Individual B owns the remaining membership unit in the LLC, but is not the manager. Okay, so again, we have these examples. The reporting company is a Florida LLC with 2 managers. Individual A and C are the managers. Individual A owns 50% of the membership units in the LLC, while individual C does not own any membership units. So we have a manager here with no ownership, and individual B owns the remaining units, okay? Ownership of membership units are categorized as a type of capital profit interest in an LLC commonly referred to as members. Whether a member is obligated or authorized to make decisions for the LLC depends on the internal structure of the LLC. In some cases, a member may also function as a manager. In this scenario, individual A serves as both a member and a manager. Individual B is a member, but without managerial responsibilities, and individual C is a manager without any membership units. All three individuals qualify as beneficial owners of the reporting company. Individual A qualifies as a manager owning 50% of the LLC membership units, wield substantial control by making pivotal decisions. This dual role establishes individual A as a beneficial owner in two ways: through the exercise of substantial control and ownership or control of 25% or more of the ownership interest. Individual B, despite lacking a managerial role or making any type of decisions, is considered a beneficial owner because of the ownership of 50% or more of the LLC membership units, surpassing the 25% threshold. Individual C, serving as manager and making significant decisions on behalf of the LLC, exercises substantial control despite not owning any of the LLC's membership units' interest. Individual C qualifies as a beneficial owner due to the exerted substantial control. So for all of you guys serving as managers of LLCs and thinking that you don't need to be reported because you're only the manager or you own no interest, you still need to be reported, okay? And they might hold you responsible because you're seen as an officer. So you really need to be careful with that. You might be personally liable as well if the company does not follow compliance. Example 4, a reporting company, right? So a reporting company in now this case is a corporation with multiple indirect owners through company Y and company C. This is a more complex example. So I'll try to explain it as best that I can. So again, a reporting company is a Florida corporation with multiple indirect, let's say it's a Delaware corporation. A reporting company is a Delaware corporation with multiple indirect owners through company Y and company C. In this example, individuals A, B, C, and F are beneficial owners. Individual A holds the position of Chief Financial Officer within the reporting company, qualifying as a senior officer, and as per the reporting rule, indicating substantial control over the company. Additionally, individual A indirect owns 27.5% of the reporting company's stock through direct ownership in company Y and company C. These intermediary companies collectively own 50% each of the reporting company's stock. Individual A owns 30% of the company's Y stock and 25% of company C stock. Consequently, individuals A ownership amounts to 15% of the company's stock through company Y and 12.5% through company C, totaling 27.5%. Thus, individual A qualifies as a beneficial owner through both substantial control and ownership or control of 25% or more of the reporting company's ownership interest. Individual B indirectly possesses 35% of the reporting company stock through company Y, which itself owns 50% of the reporting company stock. Despite lacking substantial control, individual B qualifies as a beneficial owner due to ownership or control of 25% or more of the reporting company's ownership interest. Individual C, as the Chief Executive Officer and President of the reporting company, is a senior officer exercising substantial control. However, individual C's indirect ownership interest amounts to 12.5%, falling below the 25% threshold. Despite this, individual C remains a financial owner due to the exercise substantial control over the reporting company. Similarly, individual D and E each indirectly own 12.5% of the reporting company stock through their 25. Let's go back to individual C. Individual C, as the Chief Executive Officer and President of the reporting company, is a senior officer exercising substantial control. However, individual C indirect ownership interest amounts to 12.5%, falling below 25% threshold. Despite this, individual C remains a beneficial owner due to the exercise substantial control over the reporting company. Similarly, individuals D and E each indirectly own 12.5% of the reporting company stock through their 25% ownership in company C. Unlike individual C, individuals D and E do not exercise substantial control and therefore are not considered beneficial owners. Individual F serving on the company's board of directors and making crucial decisions, exercise substantial control despite owning or controlling any stock in the reporting company, individual F is recognized as a beneficial owner through the exercise of substantial control by not holding ownership interest in the companies. Somebody's asking me if insurance companies don't have to report. It depends. If you are an insurance company under the definition, you don't have to report. And we can talk about it and I can explain that. So it depends. So somebody's asking if an officer of a corporation is to be reported. Yes, because they exercise substantial control as being an officer of a corporation. Not all reporting companies are required to report their company applicants to FinCEN, okay? So this is good news. Not all reporting companies are required to report the company to FinCEN. A reporting company is required to report its company applicants, okay? If it's either a domestic reporting company created on or after January 1st, 2024, or a foreign reporting company first registered to do business in the United States on or after January 1st, 2024. A reporting company is not required to report its company applicants if it's either a domestic reporting company created before this date, January 1st, 2024, or a foreign reporting company first registered to do business in the United States before January 1st, 2024. So I'm going to be the company applicants for all the companies that I formed starting January 1st, 2024. That's just the reality of it, because even the client's asking me to form it, I'm the one that's actually forming it. But it would be crazy for me if I have to be the company applicant for all the companies that I formed in my over 12 years of practice. I don't even know that, that they would know how to find me, God knows. But for the new companies, what I'm trying to do is I'm informing everybody that I am their company applicant and that they need to file this report. It's not part of my job to file the report for them. I just give them the information and then they can do it themselves or hire us to do it. But it's so important that if you are forming companies with people that are not letting you know of this, you keep this in mind, because at the end of the day, it's the responsibility of the company to report, okay? And here's a little chart that you can see as to who a company applicant is. Again, if the company was formed before January 1st, 2024, no need to report the company applicants only. That doesn't mean you don't need to do your FinCEN BOI report, beneficial owner. No, I'm just talking about the company applicants, okay? But if you form after January 1st, 2024, you have to report your company applicant. So what is a company applicant, or who is a company applicant? Each reporting company is required to report their company applicants, and they have to identify this to FinCEN. Every company is going to have at least one company applicant, and at most two. Get that? Every company is going to have a company applicant. Company applicants cannot be legal entities. So you cannot say, oh, I hire LegalZoom to do it, or I hire, this law firm to do it. No, you have the person that is responsible has to report this. So there are two categories of company applicants, all right? The direct filer and the individual who directs or controls the filing action. The first category is the direct filer. This person must be identified by all reporting companies that have a company applicant reporting requirement. The second category directs or controls the filing action. It may not be applicable to all reporting companies that have a company applicant recording requirement. The second category of company applicants, it's only required to be reported when more than one individual is involved in the filing of the document that created or first registered the company. If more than one individual, okay, is involved in the filing, then two company applicants must be reported. No reporting company will have more than two company applicants. The direct filer is individual who directly filed the document that created a domestic reporting company, or the individual who directly filed the document that first registered a foreign reporting company. The individual who have actually physical or electronically filed the document with the Secretary of State or similar officer. So in this case, me. Second is the one that directs or controls the filing action. The other possible company applicant is the individual who was primarily responsible for directing or controlling the filing of the creation or first registration of the document. This individual is a company applicant, even though the individual did not actually file the document with the Secretary of State. I would think this is the client that hired me to file the document. So we have me filing, the direct filer, and then whoever directed me to file, which is the client. Here is a little chart that is going to help you identify, right, who are your company applicants. If the company was not, again, if the company was not reported or created on or after January 1st, 2024, then you don't have to identify who the company applicants are. If the company was reported or created on or after January 1st, 2024, all required company applicants must be identified. The following examples illustrate how to identify company applicants in common company creation or registration scenarios. Example 1, individual A is creating a new company. Individual A prepares the necessary documents to create the company and files them with the Secretary of State or tribal office, either in person or using a self-service online portal. No one else is involved in preparing, directing, or making the filing. Individual A is a company applicant because individual A directly filed the document that created the company. Because individual A is the only person involved in the filing, individual A is the only company applicant. State or tribal employees who receive and process the company creation or formation documents, they don't have to be reported because they work for the state entity. In example 2, for example, we have an individual A who is creating a company. Individual A prepares the necessary documents to create the company and directs individual B to file the documents with the relevant state or tribal office. So here we have individual A is creating the company. Individual A prepares the necessary documents to create the company and directs individual B to file the documents, either directly or indirectly. Answer, individual A and B are both company applicants. Individual B directly filed the documents and individual A was primarily responsible for directing or controlling the filing. Individual B could, for example, be individual spouse, business partner, attorney, or accountant. In all cases, individual A and B are both company applicants. So whoever asked for the company whoever asked to create the company and whoever actually created the company are going to be both company applicants that need to be reported. So what information does the company need to report, right? And remember that not all companies are required, all companies, unless they file an exemption, are required to do their BOI report. But not all companies are required to include the company applicant. What specific information does my company need to report in the BOI report? Let's go through that. For example, the reporting company needs to report their full legal name, any trade name or doing business as, any name that reports any trade name or multiple doing business as, fictitious name, all of that needs to be reported. A complete U.S. address. They have to report the address of the principal place of business in the United States. Or if the reporting company's principal place of business is not in the United States, the primary location in the United States where the company conducts its business. Okay, so this needs to be reported. The state, tribal, or foreign jurisdiction of formation. For a foreign reporting company only, state or tribal jurisdiction of first registration. The Internal Revenue Service, IRS, EIN, taxpayer identification number needs to be reported. If a foreign reporting company has not been issued a EIN, then they need to report the tax identification number issued by a foreign jurisdiction and the name of such jurisdiction. Each beneficial owner, so that information is for the company. For each beneficial owner and company applicant, right? So we agreed each company is going to have a beneficial owner and they may have one or two company applicants. We need the full legal name. We need the date of birth. We need complete current address. We need to report the individual's residential address, except for company applicants who form or register a company during this business, such as paralegals. For such individuals, report the business street address. The address is not required to be in the United States. Unique identifying number and issuing jurisdiction from an image of one of the following no expired documents: U.S. passport, state driver license, identification document issued by a state, local government, or tribe, and if an individual does not have any of the previous documents, a foreign passport. All of this we need from the beneficial owner and each company applicant. So when and how should my company file its initial report? Again, this is an ongoing thing, right? If your company already exists as of January 1st, 2024, it must file its initial report or BOI report by January 1st, 2025. If your company is created or registered to do business in the United States on or after January 1st, 2024, And before January 1st, 2025, it will have 90 calendar days after receiving actual public notice that the company's creation or registration is effective to file its initial BOI report. If your company is required to file a BOI report, you must do so electronically through the filing system. And if there's any changes in the beneficial owners, you have to keep that updated, okay? If by chance you already submitted your BOI report and you need to make any changes or report inaccuracies, you have 30 calendar days to make those changes. Example of changes that will require an updated BOI report are any change to the information reported for the reporting company, such as registering a new DBA, a change in beneficial owners, such as a new chief executive officer, a sale that changes who meets the ownership interest threshold of 25%, or the death of a beneficial owner, or any change to a beneficial owner's name, address, or unique identifying number provided in a BOI report. If any of these things happen, you have 30 days to file your updated report, and this goes forever. So, from my understanding, entities formed under tribal regulations are required to file too. And how much I charge for the report, that depends whether it's a basic structure or if it's gonna be a more complex that requires analysis. But you can reach out to me. My contact information, I'm gonna share it shortly. But just to recap, our firm is here to assist you. We can assist you in company formation, in LLCs, corporation, including the BOI reporting, nonprofits organization, business domestications, company dissolutions, any type of license and permits in the state of Florida, drafting any type of documents or reviewing those documents, buying and selling business, trademark registration, copyrights, immigration. We do a lot of immigration. We do a lot with foreigners for investment, work visas, student visas. Real estate, we do closings, quitclaim deeds. We also do estate planning, trust, wills, successions, name changes, litigation, and we cancel timeshares. If you need any of these things or anything that you didn't see, such as probate, please feel free to contact us, and we are more than delighted to assist you. So here is our contact information for anybody that's requesting it. I want to tell you guys that we are here to assist you. We don't just practice in the BOI reporting, but we help you with all the compliance and transfers of interest. And if you guys have any further questions, feel free to send us a WhatsApp to that number shown there, or an email, or you can reach out to our website. Again, my name is Romy Jurado. I'm an attorney here in the state of Florida, and we are more than happy to assist you with everything you might need. All right, guys. Well, thank you so much. Again, Romy Jurado from Jurado & Associates. We're here to assist you. I hope this was informative. Take care, and I'll see you next time. Please reach out to us, and we'll send you all the information. Bye.